And welcome back to the Jim Paisley podcast. As always, I am your host, Jim Paisley. Today we've got a great guest, Michael Neff. We are going to change the subject a little bit. We will get into some COVID-19 stuff. But Michael Neff is a trial lawyer. He's what we would all consider a heavy hitter in the legal industry here in Atlanta and the Southeast as a whole. He's a friend of mine. He's a resource. When I have questions, complex litigation questions, he is certainly at the top of my list to call. If I have complex cases that I need his assistance, I will happily bring Mike Neff in on a case. We get into a lot of nuts and bolts of how he built a firm from taking the little small cases, and then the slightly bigger ones, then the bigger ones, and of course, the heavy and most complex cases. We're talking against large corporations, against trucking companies where they have all the clout and money on their side, and they're going against Mike. And we show really step by step how he built this firm from the ground up. What I think is really cool about Mike is sort of the humility and self-perception that he has and the patience that it took to build this firm. There is a consistent understanding that he has where he keeps adding to the team of areas where he lacks. And just to understand that and be able to do that consistently is, I think, amazing. It's about getting out of your own way to run a business the right way, of course, all in the name of the best interest of the client. So we talk about topics like tort reform, the madness and the grind of trying cases day to day, what that does to your body and your psyche, the lack of sleep, the lack of eating. I think it's pretty interesting stuff. And we get in and we talk about, the depth of what these corporations do, why they deserved or did not deserve these lawsuits. And I'd be curious to hear your thoughts on the back end of this. So anyway, tell me what you think. Message me, email me. So without further ado, ladies and gentlemen, Michael Lawson Neff. All right, Michael Lawson Neff. I had to throw your middle name in there. I don't know why, but we were just talking about it. But all right, when I think of heavy hitter in the legal industry, you're at the very top of that list. And I'm looking at a few of your recent verdicts right now. $35 million premises liability against Six Flags, $9 million against a home security system, $47 million against Hertz, although the appellate courts didn't love it as much as we did. multiple 7, 8 figure verdicts on tractor trailer cases, car wrecks, and premises liability cases. Welcome to the podcast, Mike.
Oh, thank you, Jim. It's good to be here.
Absolutely. Now, real quick, a lot of my non-trial lawyer friends, when they hear those verdicts, a lot of people immediately start thinking about tort reform. But if you could speak,
get at it.
Yeah, right, man. And we'll touch more on that a little bit later on. But real quick, tell me about any one of these cases that touched you deeply. That gave you that passion for fighting those. And as far as those bigger numbers that we hear about, when you start to know about the facts, they don't necessarily seem that big anymore. The number really is at some point meaningless. And it's, but anyway, if you could speak to that, on what these cases were about.
Well, sure. Monotronics was a home security company. And they're no longer with us for a lot of reasons. They expanded too much, I think. They filed bankruptcy. But I think the case that changed my life and a number of other people's lives was that case where our client was a lady who worked 2 jobs and owned her own home. And she paid her check every month to her home monitoring alarm monitoring company to be advised if the alarms went off. And then horribly, one day, a bad person got into our house and tricked the alarm at least 8 times. But Monotronics never spoke to the client until right before. And then when they did speak to her, they didn't tell her about all the other alarms. They didn't tell her to get out of the house. They were in a rush because they had some quota on how many calls to handle. That was more important than taking the time to go over the facts and keep the client safe. And so, unfortunately, as a result of that, the evil person in the house wind up kidnapping and raping this lady at knife point. Just a horrific experience. And we eventually went to trial because the client had enough courage and trust to let us ask a jury for justice. And this was a case in DeKalb County, and we got the verdict 11-11-11, November 11th of 2011. The verdict was $9 million, which set a record that, as far as I'm aware of, in terms of a rape case in Georgia. And what was more powerful than the number was the fact that after the verdict came out on Friday, it was Veterans Day. The courthouse was closed except for us. So we were the only people in the courthouse, and the jurors, after they announced the verdict, normally they walk through a back door and leave the courthouse. But this time they walked not out the back door. They walked up to our table in a single file line, and each of the jurors hugged my client and said something personal to her before they walked out of the courthouse. And that changed my life. I think it changed the client's life. She won the Georgia Trial Lawyers Guardians of Courage Award. It's called the Nesselhut Award. And she got a standing ovation from about 500 lawyers in the room when she received it, because she had the courage to go through something really painful at trial, because the defense lawyers were saying, why didn't you run away? And why didn't you do this? And how come you didn't know better? And she had to face all of that. And so that case was the most important professional moment in my life. And probably always will be.
Let's touch on courage for a second. And you briefly glossed over the facts there. When you talk about courage, about somebody sitting in a courtroom and confronting their attacker, not just from the criminal
Right.
standpoint, but something, and I'm sure there was a monetary award that was offered before this.
Yeah.
And I'm sure she could have ran away, but this was a case where this guy was in her house while she was on the phone with
Yes.
the security company.
Yes.
There were several conversations. He could hear these conversations, and he was still hiding there. It was basically everybody's worst nightmare.
Yes.
She was, and she goes into her bathroom, right?
Mm-hmm. Yes.
And then, where was he? This is scary as fuck.
I think he was like standing in the shower, and so when she walked in, that's when he stepped out. I mean, it really is an image from a horror movie. It's awful. So she had to. You're right. She had an opportunity to take money that a lot of people would have taken, but and she literally shook. Trembled when she spoke about it, and even took a shower with the baseball bat every day. I mean, she had really significant post-traumatic stress disorder. And somehow, you know, she has more courage than I'll ever need to have. She has more trust, I guess, than I hope I ever need to have. She trusted us, and we were really terrified to lose that case because we didn't want to think of a world where we had let her down. It was an amazing process to go through, and I think, you know, growing up watching lawyer movies or reading lawyer novels, if you're a trial lawyer, you dream of an opportunity to make a difference, and that was an amazing moment.
That is one of those bottom of the ninth World Series home runs. And I think one thing that I never really thought of was trust. Someone that has every reason not to trust anything, the system,
Mm-hmm.
something bigger than her, and she lays that trust into you. I can only think of the burden that you felt going forward. And when you talk about changing your life, I find that fascinating because I know you don't mean from a financial perspective, because anybody can get, not anybody, but you can get a big verdict. But that verdict is only as good as what the appellate court thinks it is worth.
Mm-hmm.
And
Right.
yeah, it changed your life from that point. And that case went up on appeal, and it was I'm sure it was several years before it
Yes.
was justice was actually monetarily
Yes.
delivered, at least, right?
Yeah, I mean, we tried to talk to the defense about settling, but they offered even less money. Remarkably,
I'm
there's
sorry,
a reason why.
even less money than before
Yeah,
trial.
than what they had offered me before trial.
What the?
Well, there's a reason sometimes people run their businesses into bankruptcy, and this wasn't the main reason, but it is indicative of a management concern, I would say. You know, I couldn't believe it, but yeah, we went 2.5 to 3 years post judgment motions and appellate issues, and my friend Mike Terry at Bondurant, Mixon and Elmore was the appellate lawyer that led the charge. So we won in the Court of Appeals, and the Supreme Court did not accept it. So we eventually prevailed and got paid, and was able to help the client financially as well as emotionally. I mean, one of the things that she said when she accepted the Guardians of Justice Award was that the verdict gave her self-respect back, which was, like, again, a super powerful moment. You wish that it didn't come to that, but I think there's a healing, a catharsis that can happen when there's a significant verdict, because other people recognize the harm that you went through and the injustice of that harm, and they say that was not acceptable, and we respect you as a person, and this is how much we respect what you went through. And so the money is symbolic as much as it is a real assessment of something as horrific as what she had to go through.
What was their defense at trial?
Well, it was crazy. The law firm that initially had the case, Hall, Booth and Smith, were fired and later sued by Monotronics for malpractice. And then the law firm that took it over was Carlock Copeland. And I don't often feel bad for defense lawyers, but I feel a little bad because I don't think they really wanted to try that case. I think the defendant thought it was going to be a test case, and that they would win either at trial or in the appeal. And so at trial, there was 3 defense lawyers, and one of them was a former prosecutor, I believe, and she cross-examined our client and insinuated that she could have run away at certain points or something like that. And my partner, Dwayne Adams, on redirect asked, well, they asked why you didn't run. Is there a reason why? And she said, yes, he told me that he had someone else watching, and if I ran, they would kill me. And I didn't know that wasn't true. And, to blame the victim is a gutsy approach, but unfortunately it happens a lot. But it felt like it backfired on them in a big way.
As my experience as a former prosecutor, I can certainly attest that having an overzealous prosecutor as an attorney, especially on the defense side, trying to accuse or allege blame in a case like this is extraordinarily can be a bad move. I think they tend to certainly get trapped in their own heads, in their own worlds, as far as what is good and what is bad. And they tend to think whatever, and at least my opinion anyway, and I saw that starting to happen with me way back in the day, but that whoever you're up against did something wrong, and I think that can be.
I actually was nervous that one of the jurors was going to jump over the rail and attack the defense lawyer. I mean, the body language and the facial expression I've never seen before, but at least that one person felt it an extraordinarily offensive line of questioning.
Oh man, just self-perception is everything. And
yes.
I think it's a gift to be able to keep it, no matter how good you get at one thing, to be able to keep that understanding of how you're coming across to people. And
that is probably the biggest breakthrough, I think, psychologically, was my ability to kind of track the evidence and the questions and think, where's the jury in this process? How do I have to ask this question to move this one step closer for them? As a younger lawyer, it's hard enough to know all the facts and understand the importance of them. And there's a disconnect that just because you know all the facts and why they're important, the jury doesn't, and they shouldn't be expected to. And as a younger lawyer, I had some painful experiences thinking, well, surely this is obvious that A plus B equals C. And I found out painfully that no, you better explain it a little bit better than that in a little bit more bite-sized pieces. So frequently it's A plus B plus C plus D plus E plus F equals the conclusion. And, I've found that short little bites of information will build eventually the conclusion that you want, or at least the foundation for that conclusion.
Yeah, let's get into how, I guess, the psychology of when you're going forward and how you get there. I've tried over 100 cases in front of a jury, most of those as a prosecutor, so they don't count.
Well, the law's a little bit on your side,
right? Oh my God! And so many tools that you have at your disposal to attain the result that you want. Certainly tougher than I think other parts of trial law, anyway. So, and I had a routine that I did every morning and before every trial, and it was sort of to combat anxiety and what I was up against. And it seemed like up until the jury came in the room, that it was extraordinary, and I won't get into what happened before that. But real quick, just Let me back up just a little bit more. How long have you been practicing, and where did you start practicing? How did you wind up where you are now?
Let's see. I'm thinking now. It's been 27 years since I got out of law school, and I actually started practicing in law school as a second year law student. You have 3 years in law school, and in Pennsylvania, you can practice as a second year student under the supervision of a faculty member. And I started in the family law clinic. So, yeah, that would have made it 28 years. So I moved to Atlanta eventually in end of 94. Got here before the Olympics, enjoyed watching Atlanta grow, and had the opportunity to grow with it. I started my firm in April of 1996, right before the Olympics. And, it's been an interesting ride ever since.
So as soon as you moved here, you started your firm? Or, you moved here in 94, and what did you do until you started your firm?
Yeah, I worked for another firm for about a year, a little bit more, while I waited to take the bar exam in Georgia. I had already passed in New Jersey and Pennsylvania, but moving to Georgia, I had to sit for the Georgia bar. But I opened my firm pretty quickly after passing the bar.
Yeah, good for you. Similar for me. We moved up here, and honestly, I think I was too lazy to look for a job, and I was tired of working for people. So
Right.
I was like, God, I could go do the prosecutor thing again, but I don't know. I think my wife called me out. She's like, you've already talked about opening your own firm. I won't tell you what she called me, but
Right.
yeah. So I just did it, and I'd say it's worked out pretty well. But
Yeah, it has.
so personal injury the entire time from 96 on, right?
Mostly. Actually, at the very beginning, I did a little bit of business litigation and a little bit of employment litigation for plaintiffs. And it was an interesting time period because Michael Crichton had written a book called Disclosure, which they made a bad movie out of, where a man gets sexually harassed by a woman.
Certainly terrible facts.
I think it was Michael Douglas getting harassed by Demi Moore way back when, but I don't remember.
Poor guy.
The book was much better. But anyway, it sparked an interest in fighting for the underdog. And those are really tough cases, unless you have really clear evidence. And I fought a number of them and learned a lot from that. Learned how to litigate in federal court. Also learned it was not an easy job to present emotional harm and get money for it. I had to figure that out over the next few years until I could help that lady that got sexually assaulted. I mean, that was all about that. So it was an interesting learning experience. Not a lot of people were doing that area of law. And the good news was it was relatively easy to get cases. The bad news was those cases were not easy to win. And I eventually moved on from employment law.
Good for you.
Well, it turned out to be a better business decision for me. It is really a challenging area of law for a plaintiff. Yeah.
So you go from building the small firm by yourself, you start adding staff. You're obviously, by anyone would consider, you're still a small firm, but you've got quite a team on your hand. And how did you do that? I mean, how did you build that up? Were you trying big cases immediately?
No. Yeah, no. I was trying a lot of small cases immediately.
How small?
0. unfortunately.
Like,
Zero small.
I don't mean I don't mean the jury said it was small, but I mean,
Oh, well, okay. If I had won that, a 5-figure case, a 10,000. I mean,
yeah,
I was told as a young lawyer, and I think it's great advice, that if you don't know how to try cases, or if you're not willing to try cases, then you can never get a maximum recovery because the insurance companies won't respect you. So you need to go learn how to try cases. And then I was a solo practitioner on my own thinking, well, this is probably going to be a little bit hard. Why don't I try some cases where I can't win this case, but I'll at least get some experience. And my thought was, if I'm gonna screw up, I might as well screw up in a case with no damages, so I'm not hurting anybody except the people that had to listen to me argue, because I was very raw, and I had to learn a lot of things. How to get organized, how to structure a story, how to control my emotions, how to get the psychology for the witnesses and the judge. And I mean, there's a lot of nuanced psychology involved in being a trial lawyer. So it's definitely a process, a learning process, and there's no other way than to do it. I mean, I've tried about 35 cases in my career, all of them in the civil arena, thankfully. And, I worked my way up from, $0 cases to 5-figure cases to 6-figure cases to 7-figure cases to 8-figure cases. It has been it's been a ladder. You're just trying to get up to the next step and get better every day.
and I think that is the ultimate progression that I think most lawyers probably want to avoid because they don't want it to take so long. They kind of want their cake and they want to eat it immediately.
Yes.
I know so many very good trial lawyers that, maybe out of law school they did maybe some products liability defense work in some sort of defense factory. And then they moved on maybe to a plaintiff's firm as one of their underlings. Then they went out on their own, but they knew enough. They were getting maybe some referrals from other lawyers, and they were able to present big cases immediately, even if they were faking it before they were making it. But no, not you. You went one foot in front of the other from the very beginning. So
I am old school, old school. So that was the way, and it works, but it is a slow process. It's not a get rich quick scheme at all. It's hard to get to trial. It takes a long time to get to trial. And then invariably, they make an offer before trial that makes you think, is it going to be profitable to try this case? And in particular, as a young lawyer, you have to have the discipline to say, I'm not going to take this, even though I'm going to make money, a little bit of money taking it. I'm going to invest in myself and say no to this money and take a chance on doing better, as long as it's okay with the client. This is where numbers and luck and have to collide. You have to have a client willing to say no to some money, and they have to trust you. And in the beginning, when you're a young lawyer, that's a challenging proposition. And so, I unabashedly tried bad cases when I was a young lawyer because I really didn't want to hurt anybody. I wanted to learn. I needed to learn. And, if it was a good case and a good settlement, you had to take it most times. But I would usually pick out 2 or 3 cases a year where it's like, this one should go to trial. And usually you could get 1 or 2 in. And so, you learn something from that one and you get better for the next one. And, that's the process of building up the ability to handle a big case, is one step at a time.
was this your goal from the beginning to take smaller and then bigger and then bigger?
Yeah.
And if so,
It
yeah, yeah. If that was your goal, then I just want to know where the hell you got that self-awareness and that patience to do that, because I think that sort of violates a lot of what is sort of human nature for all of us, is to get as big as you can as quick as you can.
Oh, that's an interesting thought. Well, my middle name is Lawson, and it's Lawson because both of my parents were lawyers. So I was the son of lawyers. And so I don't know. I went to law school thinking I'd be a real estate lawyer. Um, and then by week 2, I was getting called on by the torts professor to argue cases from the plaintiff's perspective, because he noticed before I did that I gravitated towards the underdog or the plaintiff. And then, when I got out, I had dreams, of trying big cases. I loved The Verdict, the movie with Paul Newman, and I loved A Few Good Men. And I loved the, Matthew McConaughey movie, A Time to Kill. And I wanted to try big cases, and I knew I needed to learn how to do that. It wasn't going to be, except in John Grisham's Matt Damon movie, where you try I think it's The Rainmaker, where you try a multi-million-dollar trial for your first trial. That's movies. That's normally a malpractice recipe. You're not ready, for that, your first trial. That's craziness. So in the real world, you want someone who's got some battle scars, and that's experience. But I was also helped. My approach got clarified because I worked with a consultant named Art Italo, probably going on 17, 18 years ago. And I still work with Art.
You said he's a consultant. What type of consultant?
He consults lawyers on their practice.
Okay. So
Yeah.
So from a business perspective, as far as
Yes.
what the law firm,
Yeah.
the direction of that, not
Yeah.
trial.
Right. He meets with divorce lawyers, personal injury lawyers, real estate lawyers, and he works with them. And this is where I really started to appreciate how much psychology there is in life and law, because he led me through a series of meetings where we talked about my priorities and what I really wanted and what I was willing to do. So there's a lot of self-analysis and self-reflection. And at that point in my life, I had been practicing for probably 8, 9 years. I'd been on my own for 6 or 7. I was making a little bit of money, but emphasis, on a little bit. And he said, Mike, you have 60 cases. Most of them are really small. You have to make up your mind. Do you want to try big cases? Because if so, you need to get rid of these cases so you'll have time to work on them. And if not, you need to get more cases. You need to get more small cases so you can do volume. And, it was a multi-week process. And eventually I said, I want to try big cases. He's like, all right, so this is what you're going to do. You're going to get rid of all your really small cases. You're going to stop saying yes to small cases. And I said, well, I'll starve. I mean, how am I going to make any money? He's like, because your bigger cases will get better and you'll make more if you spend more time on them. He was and is astute enough to say, hey, look, at a certain point, all you can do is spend your time putting out fires. You can't really devote the energy to a case like the ones that we work on now if you have too many cases. And it's kind of like that Tom Cruise movie where less is more, the agent. I forget, Jerry Maguire. Yeah. So that was Jerry Maguire moment for me. And that was that was the next step in the process, was getting leaner to get stronger.
One of my next questions was going to be whether you had a mentor, and I think that sounds like some really good. You call it consulting. I call it business mentorship. You know,
I paid him, and
yeah.
I still pay him. He's a great guy, and he doesn't do it for free, but it was worth the investment, certainly.
And let me ask you real quick: is he still
Yeah.
he still doing his thing?
Yes,
And
absolutely.
give me his name again for anybody listening.
Art Italo, Italo, and tell him Mike Neff sent you.
Sure, that's great.
He joked to me once that a young lawyer was impressed that I was one of his clients, and he said, "Well, I knew Mike Neff before he was Mike Neff." I'm like, "Art, who was I before I was Mike Neff? I was Mike Neff." I mean, it's just kind of like people's perception on it. It's a journey that, not everyone can do, but the path is out there. It's just, can you do it? And it requires some luck. I won't deny that.
I hear a lot of very highly successful, big time achievers attributing their success to luck. That's a common thread I see. So let's get more into, and I think luck is consistently, taking advantage of being in the right place at the right time. And, but
that's part of it.
Yeah. But, let's get into more of your secrets of what makes Mike Neff, right?
Right.
You and me have talked about some of this before, but, what are your daily routines like in the morning? Do you do crazy things like meditate? What gives you your daily discipline of?
Well, yeah, COVID-19 has changed a lot of things. We're doing this at the end of April of 2020, so my daily routine is a little different, and I do meditate now, and I have for a couple of years, but that's not how I started. It's funny. Someone suggested that to me about 20 years ago, and I looked at them like they were a tree-hugging hippie from California. I wish I had listened to him. I don't know everything. I should have done it, because dealing with pressure and stress is a big part of the job. And I do highly recommend meditation as a way to break the stress and anxiety that's part of this job. Unfortunately, it's, no getting around it. It's going to be there. And, you either need to work it, or it's going to work you.
I remember the days of trying lots of cases and dealing with the pressure and having multi-day trials, and then thinking about sleep or eating was just non-existent. The way your stomach would feel.
I'll tell you a story, and it's not a healthy one, but during that monotronics trial, I got anywhere from 2 to 4 hours of sleep a night, and it went down as it was. Thankfully, it was only a 1-week trial. I've tried 2 and 3 week trials, but my partner Dwayne did not sleep the night before closing, which was Friday. So I've changed some things because I recognize at the end of that trial, I really shouldn't be driving right now. I'm too tired. And Wayne fell asleep during jury deliberations. After we did our closing arguments, and he did an opening close and I did the closing close, jury deliberated for about 2 hours, and he was so tired he actually fell asleep. I was pretty tired too, but I couldn't fall asleep. So I remember sitting in the hallway of the empty courthouse in DeKalb County with the lights out in the hall, and it approaching dusk, and just sitting and waiting.
It's like something out of a movie scene,
It was. In fact, there another lawyer movie that wasn't as good as the book was called Civil Action, written by Jonathan Hart. It was a great book about mass torts and a guy that was on top and fell to the bottom. Loved the book. The book was very influential to me as a young lawyer. Movie wasn't so great, but there's a great scene with Robert Duvall approaching John Travolta in the hallway while the jury's out, or the judge is out. I can't remember which part of the equation, and sitting down next to him in a dark, quiet hallway. And that was kind of my moment, except no one came up to talk to me about settlement.
Yeah, that's what else can we know about your routines as far as regular firm discipline that gets you, that puts that one foot in front of the other to get where you are?
Well, our firm now, we have 4 lawyers, myself and partners Susan Kramer and Dwayne Adams, and then Shane Pegler. And we all have very different roles. And sometimes it looks like I was really brilliant and planned some things amazingly well. And in reality, that's not how it worked. The pieces just fit really well. So Dwayne tries most of the cases with me, the big ones. And he's very different than I am in many respects. He's 6'4". He's African American. He doesn't drink alcohol. He doesn't eat meat. He doesn't swear. He's the son of a preacher.
He's very good looking. I mean,
well,
you are as well.
You each their own, Jim. So I call him Mini-Me because it's a joke. He's really different than me, and he can quote scripture, and he's very calm, and so we are fire and ice. And I hired him probably about 15 years ago as a second-year law student. And he had worked at SunTrust Bank before going to law school. And I thought, this guy is stiff. He's going to go, be a corporate lawyer someday, but, I need some help now, so I'll hire him. And fortunately, he's still with me. Shane, I also hired as a 2L, and he's probably been with me 12 years. And he's a former English professor from Clemson. And so he writes extraordinarily well, and he's very detail oriented, which is a big help to Dwayne and I, because we are more big picture guys. And then Susan Kramer has also probably been, about 10 years. I hired her because she had been at a firm who led by Charles Mathis, who was a superstar trial lawyer. And unfortunately, Charles got ill and died prematurely, and Susan was a free agent. And I figured if she was good enough to work with Mathis for the amount of time she had to be good. And she's a nurse lawyer, and she's really great at looking at the details of the medicine. And so we have a team approach, where we have specialists that work together and collaborate together. And, I didn't have a design, drawn up in my office, like I'm going to hire one of these and one of these and one of these. I wish I were that smart. I could have done it earlier. But it was, finding people that were willing to buy in on an approach where what we really care about is doing great work and being successful. And that requires personality fits and complementary approaches. And that's part of the luck. I mean, what are the odds? Susan, I met because I asked for referrals from other GTLA folks, and someone said, I know who you need to hire. But Dwayne and Shane were law students that I picked from resumes. What are the odds that they're going to stick with you for double-digit years? I mean, that's
crazy.
God smiled on me with that. I mean, I don't take particular credit for saying, "Oh, well, you're going to be this. I can see that, and you're going to be this." Susan was a known commodity. I knew she would be, fitting in because I was hiring a veteran, not a student. But anyway, yeah, that's part of the luck.
That's something you don't see much of. You can have a great legal team, but across the legal industry, whether it's Georgia or across the United States, I know so many big trial lawyers that when they have a really really great associate, that associate wants to go on their own, build their own practice. You've got these partners, associates, whatever you call them. They bring their own talents to the table, but there is again getting back to that self awareness as a trial lawyer. What you lack, you build a team around you that makes up for what you don't have. And just having that self awareness, that lack of an ego, I think is extraordinary.
Shane has given me some credit for what he calls building a corporate culture or a law firm culture. And he's given me credit because he said, "You've never asked us to do anything that you weren't willing to do." And of course, I had to do everything at the beginning. I licked stamps and envelopes. I made photocopies. I mean, I was literally a one-person shop at the beginning. And so, yes, there, I guess, is an authenticity about that. And maybe that does strike people as having some integrity because we've kind of evolved. We've all gotten better and all figured how to do this collectively on a higher level than what we could do it on our own.
So let's change directions a little bit. We brought up premises liability earlier. When most people think of premises liability, they think of slip and falls, trip and falls. A lot of times those tend to be smaller cases, highly litigated, very it's like bumping your head against a brick wall. But that's, of course, I can't have you on the podcast without talking about what premises liability really is. And you wrote a book on it. So if you would, what was the name of that book and why did you write it?
Well, I know we're not doing video, but this helps me. Premises liability, a guide to success.
I've got my copy of that, but it's not on my bookcase behind me because we just moved. So
okay.
It's in a box downstairs.
Good deal. It's a crazy story how that book came about. People in Atlanta will remember Snowpocalypse or Snowmageddon. That was the genesis of this book because I had lunch that day with a young lawyer. And I remember walking in to lunch at Twist, which is no longer open, at Phipps Mall, and seeing the first flakes come down and think, well, I'm only a mile and a half from my house, no big deal. And I'll probably be done in an hour. So I was wrong. During that lunch, this young lawyer was asking me about the Six Flags trial where we had gotten a $35 million verdict. And he looked at me and he said, "Mike, when you were in law school, did you ever see this coming? Did you ever know that you would try a $35 million case?" And that question hit me like a ton of bricks. It was like in the movies where the screen goes fuzzy or wavy and you move back in time. And I went back and thought about, who I was in law school. And it probably was only a couple seconds, but it seemed like a minute and a half or 2 minutes. And I looked up and said, no, I couldn't have conceived of a $35 million verdict in law school. I just wanted to be good, and I thought I could be good. I didn't know any better. I just wanted to be a good trial lawyer, and it evolved into something more. And then he asked a lot of questions about mile markers on the journey, and it was an hour and a half lunch, and that's the good news. The bad news was it took me about an hour and a half to get home, and it was a mile and a half. So it was I got home and that lunch stuck with me. Um, and in April, a couple months later, that lunch nagged at me like, there's a message here, there's a story. It might help other young lawyers. And I called Trial Guides, who is a publisher out of Oregon that publishes to the plaintiff's bar. And I said, I think I have a book idea on premises liability. And they said, give us a proposal. And I said, okay, what's a proposal? And I did one and they said yes, which I was really happy and amazed by, because a lot of my mentors wrote books for Trial Guides that really helped me in refining my approach. So Premises Liability, A Guide to Success was book one, and I just completed book two.
Yeah, what is that?
It's also a premises liability. It's going to be trial related though, and it's expected to be published probably the third quarter of 2021. But I've given them all of the book, so they're going to edit it, and my work is predominantly done.
Tell us more about what is premises liability. Like I said, most people think slip and falls, but no, it's not
Right.
that at all.
Well, premises liability can get broken down into these two words: premises, which relates to the property that's owned, and the approaches to the property. And the approaches are, how do you get onto the property? How do you get off the property? Once someone buys a piece of property and they invite other people on that property to do business, especially, they have some responsibilities under the law. Their responsibilities are to act with ordinary care, to do what reasonable people should do to keep the premises safe. And if they don't do that, they can have liability or accountability or responsibility. And so premises liability cases are cases that derive from owning or operating a piece of property. And again, businesses are held to a higher standard practically because they're there to make money. They should do so the right way. So theme parks, movie theaters, office buildings, hospitals, nursing homes, construction sites, these are all, unfortunately, locations where people can get seriously injured or killed if safety rules aren't followed. And when I started practicing law, premises liability cases were like the redheaded stepchild that nobody wanted, because they didn't think they could win, because there was a real stigma about them. You go back to movies. I must have watched a million movies, because I remember one with Walter Matthau, and he was scamming the insurance company. He was pretending to slip and fall on a banana and have these awful injuries. I can't remember the name of the movie now. It came out in the late 60s. This was a comedy, right? It was a joke about how crooked lawyers and crooked claimants would scam honest people by pretending to get hurt on a fall. So that's a pretty bad scenario. But the reality is, every day people get hurt that shouldn't get hurt because safety rules aren't followed. And that's real and that's serious when that happens. And so premises liability law gives juries an opportunity to hold people accountable if they don't follow the safety rules, and people get hurt because of it.
Give me more, a couple practical examples of cases that you've handled, maybe a 30-second synopsis of each one, just to give folks an idea of what kind of situations we're talking about. Because you're not talking about a simple little mistake. You're talking about times they
right.
knew about the danger it presented. There is evidence that they knew a lot of times about people routinely getting hurt, and they just
Right.
chose to do nothing or chose to ignore it. So, give me a few examples of what these cases were.
Sure. Well, I'll start with Monotronics. There were at least 8 alarms triggered. There were actually more that could have been triggered, but they chose to put the alarms on hold, which was crazy. They didn't want to be bothered making extra phone calls. And so they also had a corporate culture where they wanted to handle calls. So they rushed through rather than looking at the alarm history. And so they violated a lot of rules. We had an expert come in and explain how to run an alarm monitoring company safely. And the jury said, yeah, if you had done it the right way, she could have run out of the house and this never would have happened. So that resulted in a $9 million verdict because safety rules were broken.
What about Six Flags? That's a premises issue, but I
Yes.
even had a caveat to it that it was not on the actual Six Flags
Well,
campus.
yeah,
But yet,
the Court of Appeals, went one way and the Supreme Court went a little different. So what happened in Six Flags was that a customer went to enjoy high school graduation, and he wound up getting beaten by a group of people. There was evidence that there were gang members involved in this group, and there was evidence that those gang members were Six Flags employees. There was evidence that there was gang graffiti in the men's locker room and had been there for years. And Six Flags claimed they didn't know about it. They would have investigated. And there was also evidence that Cobb County police officer had suggested they have security at closing time 7 days a week. They'd only paid for it for 2. And so the jury looked at it and said, you knew better. You should have done something. You wouldn't spend the money. We're going to hold you accountable because the gang that attacked Josh had gotten into prior trouble in the park. They got thrown out of the park, but were still on Six Flags property when they picked out Josh, who was also on Six Flags property. And then they followed him to the bus stop that handles taking people to Six Flags. And they jumped him there. And Six Flags wanted to say, well, it wasn't on our property, but a lot of things happened on their property. It was a continuous chain of events. And so that was a $35 million verdict because the client got beaten into a coma. He had permanent brain damage.
when you say
So
permanent,
that,
I mean he's permanently a 10-year-old in his brain, right?
well, I won't get into specifics about that, but the evidence at trial was significant that his ability to have long relationships was compromised. His ability to take care of himself was destroyed. So there was evidence, there is evidence, and the damages were significant. I mean, really lifelong, permanent. There are challenging cases. We sometimes joke that we got known as a firm for doing Mission Impossible, but there are definitely challenges to putting these cases together and having them make sense.
Give me an
Because,
example of some of those legal challenges.
well, they're not always legal challenges. Actually, the law is pretty good. They're mostly psychological challenges. And when I first got into it, I sometimes didn't understand how to frame it for a jury. When I heard about slip and fall cases, I had a negative connotation, but it's before I knew how significant an issue falls are. The CDC has a really good website and it addresses, how many people get hurt by falls and what the cost to society is as a result of falls and how preventable falls can be. There are a lot of safety materials. Railings should be a certain height. Slip proof mats can get put down on places that are known to be wet. Certain cleaning materials shouldn't be used because they're, slick on certain surfaces. There are things that we now know that we didn't know. And I think if you look at a premises liability case from the perspective of teaching the jury, here's how you can help keep people safe. It's not controversial. These rules have been known for years. Did the defendant follow the rules? So the answer for us is no, because if they follow the rules, it's probably not a good case. But unfortunately, they frequently don't follow the rules, and people get hurt. And they don't have to, because if you follow the rules, people are generally kept safe.
You've got these cases, these premises cases. You go through litigation. I can imagine the insurmountable written discovery you have to get through. I can imagine the data bombs that they just sort of drop, the truckloads of paperwork that you have to sift through. You get through all that. Do these ever settle pre-suit? Is that something that's typical, or is this something that's you started with the intention on this is going to trial and we need to prepare the client with that expectation, and we need to prepare our evidence and everything like we are actually going to trial?
Right. Well, we have a firm motto that if we take the case, we have to be prepared to try it. And if we're not prepared to try it, we shouldn't take it, because these cases typically don't settle before filing suit. I've tried multiple times, and I've pretty much given up hope, but every now and then I'll still ask. I think there is so much skepticism on the defense and insurance company perspective, their worldview. They don't understand how a jury is going to hold against them. And they don't understand how it could be for a significant amount. Generally, there are exceptions. And so, Six Flags, I have an email that I posted on my wall in my office. Even I've left it up, even though the case has been over for years, about the defense lawyer writing to my co-counsel saying that I wasn't being reasonable and that he thought I was putting the client at real risk. That led, after the verdict, we were all talking to the jurors in the hallway, and you could hear him 80 feet down the hall talking to a juror saying, "We're shocked by this result." And I turned to one of the other jurors I was talking to, and I said, "The defense is shocked by your verdict." And the juror responded to me, "Of course they're shocked. They've been in denial for 3 years."
Wow.
So, it is powerful psychological forces that we're up against.
I hear this from the other side, and myself, I'm a plaintiff's attorney as well, but from the defense side, I hear, man, these verdicts, these monster verdicts we're getting lately. I'm like, what about I'm like, that, when I hear that, I'm like, when a big verdict, I'm like, yeah, there are some, yours and some others. I'm like, wow, that's pretty huge. But I hear the smaller verdicts, the zero verdicts, or a judge throwing a case out, or the appellate courts throwing stuff out. And when you look at the devastation these people went through, that in my opinion seems obvious, it's the zero verdicts that shock me the most, much more than any large number. And I guess that's what they expect. They don't see, maybe getting in, when you look at when you have a mindset for so long, whether you're a prosecutor lifelong or you're a defense attorney lifelong, you just tend to see it. You get sort of more and more in your home. Yeah.
I feel that there's an industrial mindset that creeps in, and they have a hard time appreciating how someone might see it differently.
Which they're
working off of history.
Right. And I would expect that this makes these cases harder to resolve at mediation or otherwise, right?
Absolutely. Yes, and their valuations tend to be much lower. Although, since we have gotten some notable verdicts, we have seen the defense adjust to our cases, and they still fight them hard, frequently even harder, but they frequently adjust their attitude right before trial. And the numbers that we've been able to get for settlements, kind of like going back to that story. No, I didn't know that you could do that. Like, we settled a wrongful death car wreck case for $6.75 million, where the policy limits were $100,000. That was a big win for that family. Could have been more if we tried it, but it was the right thing to do to change that family's life after the loss that they had suffered. But they fought for years that it wasn't going to be worth more than 100, and then they paid 66 times that.
Yeah. Wow. That's, and they had a chance to settle it for 100, and they didn't.
They did.
Yeah.
They did.
That's what blows my mind. People are like, oh my gosh, that's such a huge verdict. I'm like, you got to think about what the insurance company didn't do. They had a chance to settle a case for 25, 50, 100, 300,000 when you've got serious injuries, if not death.
Right.
A catastrophic case and then they want to complain that they need more tort reform. So let's Swift. That brings up something that I want to talk about real quick. We brought up tort reform a little bit earlier. I brought it up, and I'd like to know, what are we looking at as far as the future? I'm sure your ear is more to the ground than mine. And I know we got to wrap this up in just a couple minutes, but what is the Chamber of Commerce or the powers that be, the insurance companies, what are they trying to do locally and nationally right now?
Right. Well, I just finished 2 biographies of Warren Buffett, who bought Geico. And they're bright people on the other side. They want to make money, and they don't want to spend money. And so what they're looking for are usually caps on how much a jury can give, or the elimination of liability in certain perspectives. And, our country was founded on the principles of letting a jury figure out what the truth is, and letting a jury figure out what the value of someone's loss is. That's the 7th Amendment to our Constitution. And so
it's pretty specific.
Yeah. There's a lot of talk about, progressives and conservatives. I think changing the Constitution by taking away the powers of a jury is pretty radical. I think letting there be a separation of power between the government and the jury who evaluates the cases is pretty conservative. That's why we have jury trials in our country, because we didn't trust politicians to set numbers, because they can get paid for by PACs. So we didn't want an unjust monarchy, and we don't want unjust political partisanship. The way to avoid that is to continue as we've done for 200 years and let citizens assess what someone's losses were.
I'm glad you mentioned that. I know, and this is not a leftist or conservative issue. I've heard many conservative trial lawyers say words like, if you believe in taking responsibility, which is a big part of their talking points and platform, then tort reform is vastly against that.
That's right.
It allows corporations to evade responsibility categorically.
The Federalist Society is a conservative organization, and one of the things that they don't like is the federal government meddling in states' issues, and the federal government mandating what we can do in Georgia and how we handle our trials is a violation of that conservative thought process. So if you talk to a number of conservatives, and I have, most of them that I've talked to will agree that this is wrong. We should abide by the Constitution, and we should let juries continue to do the work that they've done for 200 plus years.
I recently read that some of the proposed tort reform in Georgia stalled in committee and didn't get out. That made me smile a little bit. That was sort of a month or two ago. And but it's one battle after another, and I think the biggest way to fight that is just awareness. So, and I'm like, gosh, if you care about gun rights, I mean, the Seventh Amendment touches on every single one of those things. The government telling you what you can do,
Mm-hmm.
But well, I appreciate that. I know we're a little bit out of time here, but real quick, where do you get most of your cases from? Are they lawyer referrals? Do they come organically? Where do you get most of your cases?
Yeah, most cases come from other lawyers. We're gratified that we also get cases from former clients that recommend us, like the case that settled for $6.75 million, the car wreck case. That was referred to us by a member of Josh Martin's family. And she recommended us to a fellow parishioner in her church. So, that is very gratifying that, one family would reach out to another family and say, hey, look, we put our trust in Neff Law and they came through for us, and I suggest you give them a call. So, between stories like that and, working with other lawyers, because, no one can do everything. If you put me in charge of 200 cases and said, Mike, settle them all, I would be a failure at that, because my mindset is, fight, 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 and I would not be able to get that task done. So it's unreasonable to suggest or expect that someone handling 200 cases would be able to spend the time on a really big one that it demands. And so what's necessary professionally sometimes is you find the right home for the right case with the right lawyer. And doing the right thing for the client means sometimes, a lawyer doesn't take primary lead on a case. He lets someone else do it. And if a case doesn't hit our threshold, we send it to lawyers who do work on those cases, because it would be just as wrong for us to work on cases that we're not equipped to deal with.
I think it's good that the Georgia bar, at least, is very good about attorney referring cases to other attorneys that are better than them. It rewards them for making sure these cases get in the right hands. And I think that's certainly a benefit, I think, practicing law where we are. And I used to practice in Florida. I don't anymore. I don't know how it works in other states. But I think what's great about what you've told me today is what we can learn from this as far as self-awareness, self-perception, getting out of your own way. And I think that's kind of one of those big ways that you've been able to build your firm to where it is. So that's really neat. So give us real quick the title of those books, the one you wrote and then the one that is coming out soon.
So the first book, Premises Liability, A Guide to Success, it's written by it's published by Trial Guides. I don't have a working title for the second book other than maybe Premises Liability, A Trip Through Trial or something like that, because its focus is going to be trial based, where the first book was case selection, dealing with experts, looking for facts to survive summary judgment. So I kind of equate them as a introductory class and a more advanced class.
So maybe what we can do is when that second title comes out, we don't know what it is yet. I wanted to get more in the mechanics of premises liability, but we ran out of time here. But maybe we can have sort of a more in-depth legal discussion of the trial step by step with that second book. And I will certainly get a copy of that. I can't wait. Where can people learn more about you?
Well,
Besides buying your books,
like Google us. Our current website is mlnlaw.com, but one of our COVID-19 projects has been to update the website. So I think you're going to see a new website relatively soon, Neff Injury Law. And it's just a refreshing of it, better technology and a cleaner look. So, neffinjurylaw.com is in the near future.
and if people want to get in touch with you, they've got a case they want to talk about, how can they find you?
Sure. My phone number is 404-531-9700. And my email is M as in Mike, Neff, Neff, at mlnlaw.com.
Excellent. Well, Mike, it's been a pleasure having you on. I think it's very educational, and then just getting inside your head as well, as far as what it takes to get where you are. It's a long road, and people need to know that it's a marathon. And
Yeah, it is.
and I think I can hear the homeschool kids coming up now. So
Yes.
well,
Yes. Thank you,
COVID-19 law office isolation. So
Yes.
Well,
It's
thank
good
you.
to see another human
Absolutely.
outside of my family.
Well, it's great seeing you, and hopefully it won't be long before that comes out, and we'll have you back on. And again, Michael Lawson Neff, thank you for coming on the podcast. It's been cool.
Thank you, Jim.